All right, let's just jump right into a story that, honestly, sounds kind of made up. We're talking about a group of elderly ladies, a Christmas charity for kids in need, and a homeowners association that decided to take them to a full-on legal hearing. Yeah, this isn't just some petty neighborhood drama. This is a masterclass in rules, fairness, and, well, power.
So that quote you just saw? That's straight from the official petition filed by a woman named Ferne Skidmore. For about 6 years, she ran this thing called the Stocking Project. All they did was use the community clubhouse at Velda Estates as a drop-off and pickup spot for materials. The whole point was to give stockings filled with stuff like toothbrushes and little toys to homeless kids. Super simple, right? But in 2015, her HOA board banned the project from the clubhouse, and Miss Skidmore, she decided to fight back.
So the big question, right? Why on earth would an HOA ban a charity for kids? Well, when this all went to a hearing, the board president, a guy named Roger Walklin, he laid out their official case. And it all boiled down to 3 very specific reasons for kicking the Stocking Project out. Okay, so here's their argument in a nutshell. First, they claimed that because the project was tied to Christmas, it was a religious activity, and that was a no-go. Second, they were worried that some small cash donations weren't being handled by the HOA's official treasurer. And third, they argued that too many non-residents were helping out. I mean, on paper, it kind of sounds like they're just trying to enforce the rules, right?
Well, this is where things get really interesting. See, those official reasons, they were all given under oath. So what happens when you start pulling at those threads? When Ferne Skidmore's side gets to ask some questions and present their own evidence, let's just say the HOA's case started to fall apart, piece by piece.
Now, this is where your jaw might drop a little bit. The board bans the Stocking Project because of its religious affiliation with Christmas. Okay. Yet, under oath, a board member testified that the HOA board itself starts every single one of its meetings with a prayer. And, as if that's not enough, they also admitted to decorating that exact same clubhouse with a Christmas tree and lights every single year. So the rule was, let's just say, not being applied consistently.
And yeah, the other 2 arguments, they didn't hold up much better. The money thing, Miss Skidmore testified she'd only gotten about $250 in cash over 3 years. Meanwhile, the HOA had no problem with card games happening in the clubhouse where money changed hands all the time. As for the non-members, turns out non-residents were playing in those card games and on the shuffleboard courts all the time. No big deal. The rules they were using against the Stocking Project just didn't seem to apply to any other activity.
So with all this testimony on the record, an administrative law judge had to step in and make a decision. The HOA's reasons were looking selective at best. The judge had to weigh the evidence from both sides and use a specific legal ruler to figure out who was telling the more likely story. And that standard is called preponderance of the evidence. Now, it sounds super formal, but it's actually a really simple idea. We're not talking about proof beyond a reasonable doubt, like in a criminal case. It just means the judge has to decide which side's story is more probable, even if it's just by a 51 to 49% margin. Was it more likely that the HOA was fairly enforcing its rules, or that it was unfairly targeting the Stocking Project? The outcome was, well, pretty clear. The judge concluded that the evidence overwhelmingly showed the board's actions were discriminatory. Their own bylaws said that rules may not discriminate among owners, and the judge found that is exactly what they had done. Miss Skidmore had proved her case. She won.
And the victory wasn't just symbolic, it had real teeth. The judge ordered Velda Estates to actually comply with its own rules from now on and, crucially, to repay Ms. Skidmore the $550 she had to spend on the filing fee just to bring the case. The HOA literally had to pay for its discriminatory decision.
So, why does this one case in one neighborhood matter to the rest of us? Well, before we get to the big lessons, we have to talk about how the ruling became final. Because in this kind of process, the judge's order wasn't quite the last word. A higher state authority had a chance to step in, and a countdown clock started ticking.
This timeline shows how it all became official. The decision comes out on September 15th. The state's Department of Fire, Building, and Life Safety had until October 20th to jump in and change or reject the decision. They didn't. They let the deadline pass without doing a thing, which basically means they accepted the judge's ruling. So on October 28th, that decision was certified. It became legally final and binding.
So what's the big takeaway here for anyone living in a community with an HOA?
Well, this case proves that an HOA can't just make up reasons to target a person or a group they don't happen to like. They are bound by their own rules, especially those non-discrimination clauses. It also shows that those rules have to be applied the same way to everybody. And maybe most importantly, it proves that a single, determined resident, when they're armed with facts and credible testimony, can absolutely stand up to their board and win.
And all that leaves us with a final thought. I mean, look, this was one charity project in one neighborhood in Arizona, but the principles here are universal. It kind of makes you look at your own community, right? Whether it's an HOA, a club, even your workplace, and ask, are the rules here being applied to everyone equally, or are they just tools to be used against whoever happens to fall out of favor? It's a question really worth thinking about.